Congress set to hear arguments on the John Lewis Voting Rights Act tomorrow. It brings back key parts of the 1965 Voting Rights Act that the Supreme Court gutted in 2013. NBC News Now correspondent Priscilla Thompson explains how that court ruling disenfranchised millions of non-white voters.
Allison, this is the site of the latest battle over voting rights, a fight that may not have even existed here in Texas were it not for a Supreme Court decision nearly a decade ago. Since the November election, hundreds of bills have been introduced in state legislatures across the country aimed at restricting the right to vote. Legislation that voting rights advocates and Democratic leaders say are aimed at disenfranchising non-white voters, reminiscent of another time in history.
We are witnessing an attempt at the greatest contraction of voting rights since the end of Reconstruction and the beginning of Jim Crow. So how did we get here? Many point to a 2013 ruling by the Supreme Court that struck down an essential part of the Voting Rights Act of 1965, effectively gutting the legislation. The Voting Rights Act was designed to ensure that state and local governments couldn't pass legislation denying an equal right to vote based on race. Up until 2013, the bill was praised by lawmakers on both sides of the aisle. In 2006, Republican President George W. Bush even extended the law for 25 years.
By reauthorizing this act, Congress has reaffirmed its belief that all men are created equal.
But the Supreme Court decision in the Shelby County v. Holder case turned that on its head. It enabled 9 states, most of them in the South, to change voting laws without federal approval, known as preclearance, a rule that had only applied to jurisdictions with a history of discrimination in voting. The majority, led by Chief Justice John Roberts, said that racial disparities in voter registration and turnout that existed in the 1960s was no longer prevalent, writing, quote, "Nearly 50 years later, things have changed dramatically, largely because of the Voting Rights Act. Voter turnout and registration rates in covered jurisdictions now approach parity. Blatantly discriminatory evasions of federal decrees are rare. States immediately began strengthening voter ID laws and redistricting. This year, lawmakers in 48 states have introduced at least 389 restrictive voting bills, according to the Brenham Center for Justice, which tracks these bills. So far, 14 states have signed those bills into law. Texas is the latest voting rights battleground. Senate Bill 7 would make it harder to vote by mail, empower partisan poll watchers, and impose penalties on election administrators.
This enforcement mechanism is important to ensuring that we have an opportunity to make sure our voter rolls are accurate and up to date.
Last month, the Republican-controlled legislature failed to pass the bill after Democrats who opposed the new measures walked out in the final hours of the legislative session.
If Texas passed a law like Senate Bill 7 at a time when preclearance was still in place, it would be up to Texas to prove that the law would not make minority voters worse off. And because the law contains a number of restrictions that do make it harder to register and to vote, it certainly appears that at least parts of those laws would likely have been blocked by the Department of Justice.
Governor Greg Abbott says he'll call for a special legislative session later this year to bring the bill back up for a vote. Other states, like Georgia and Arizona, have passed similar laws, putting restrictions on drop boxes and voting by mail.
Make it easy to vote and hard to cheat. The bill I signed into law does just that.
Both are states that would have been covered by Section 5 of the Voting Rights Act. Now, Democrats are looking for new ways to bring back some of the protections previously provided by the Voting Rights Act. The For the People Act, passed by the House in March, would force states to offer at least 15 days of early voting, universal access to mail-in voting, and same-day registration. It would also make Election Day a national holiday.
But we're not giving up. I'm going to fight like heck with every tool at my disposal for its passage.
But the bill is subject to a filibuster.
I'm not supporting that because I think it would divide us further.
Manchin does, however, say he'll support the John Lewis Voting Rights Advancement Act.
Anytime any state or locality made an election change, they would have to get approval from the federal government. It's not clear if such a sweeping law would survive Supreme Court scrutiny if it indeed passed.
While moderate Democratic Senator Joe Manchin and Republican Senator Lisa Murkowski have expressed they would support the John Lewis voting rights bill, that too would need at least 60 votes in order to advance. This week, Minority Leader Senator Mitch McConnell signaled he would not support that bill, calling it, quote, unnecessary.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here. And click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.